So in this video we're going to have a look at the fundamental rights and civil liberties that are protected in the UK. Okay, so the concept of human rights attempts to identify human interests which have special status in the sense that they should not be violated. There are no agreements as to how we identify human rights or which rights are human rights. Some claim that they are revealed by God, others suggest that humans just have some kind of special dignity and that these rights protect these dignities. So the first piece of law that we're going to look at in this video is the European Convention of Human Rights, or on human rights. Under the UK Constitution, the ECHR has three roles. 1. Individuals can petition the ECHR in Strasbourg, alleging that the state has violated their rights under the convention. The court might then award compensation or require the state to change their laws. Decisions of the ECHR are binding only in international law and therefore have no direct effect in domestic law, which is something that is unlike the EU's Court of Justice, where decisions are binding at a domestic level. So we can see here that the ECHR has a system where you can petition to Strasbourg, where the ECHR is situated, and decisions only have international law effect. They have no binding effect at domestic level. The second point is that as a treaty, the convention should be taken into account by domestic courts when interpreting statutes. So when we just looked in the previous slide, it said that the ECHR only has international law status. The idea that our domestic courts should interpret the ECHR as well in domestic cases gives it that domestic law status through virtue of it being taken into account by UK courts. It is also argued that the common law should develop and reform in the light of this convention coming into effect. So this was taken into account in the case of AG and Guardian Newspapers Limited, which was in 1998. The third aspect is that the Human Rights Act of 1998 incorporates the main rights listed in the convention, but it's very clear that it doesn't list the convention itself. And it lists these rights into UK law and provides special mechanism for applying them. So points 1 and 2 of the ECHR are not affected by the Act. And we can see, if we look at the reference to the Human Rights Act, in the case R and Secretary of State, the Lord Bingham pointed out that rights under the convention differ from rights created by the Human Rights Act by reference to the convention. So there is still a little bit of inconsistency between the ECHR and the Human Rights Act. But the Human Rights Act effectively allows for UK courts to hear human rights cases. So whereas before you had to appeal to Strasbourg and have your case heard there, you can now have your case heard in the UK, which is cheaper and it's a lot easier to do. So, as we've already said, the Human Rights Act does not incorporate the ECHR into UK law. It rather draws from the ECHR itself. All legislation must be interpreted in accordance with the Convention rights, and the Act provides remedies enforceable in the courts against public authorities who violate Convention rights. The Act does not provide an override of parliamentary sovereignty, so the courts cannot strike down parliamentary legislation through judicial review using this Act of Parliament. This would be against parliamentary sovereignty. It would suggest that Parliament can be a future Parliament can be bound by the actions of a previous Parliament, which is against the principle of parliamentary sovereignty. It does not include Article 1 or Article 13 of the Convention. It applies all legislation, whether made before or after it came into force. So the Human Rights Act also has this retrospective authority. It applies to previous laws that were passed before the Human Rights Act. So the principles of the Human Rights Act is that where primary legislation, i.e. parliamentary statutes, is incompatible with the Human Rights Act, the court can draw attention to violations by making a declaration of incompatibility. There is a fast-track procedure available in special circumstances to enable amendments to the legislation to be made. The Human Rights Act can be directly enforced only against public authorities by a victim defined in accordance with the case law of the European Court. Okay, so this is where we really start to see the difference again between legal sovereignty and political sovereignty. Okay, Parliament doesn't technically need to pass its legislation in accordance with the Human Rights Act, because the Human Rights Act is just a piece of legislation like anything else. However, Parliament has and will continue to make special requirements to amend legislation in accordance with the Human Rights Act, because Parliament does have its restrictions on its political sovereignty. So, as we have said, the Human Rights Act does not include any provisions overriding parliamentary sovereignty, any legal provisions, okay? It does almost have this ethereal political authority to do so. However, legally it has no authority. This does again bring into question the distinction between legal authority and political authority. Okay, so we've just talked about how Parliament would be perfectly within its legal authority to override the ECHR and pass legislation which is incompatible with it. But Parliament is kept mostly in line due to its political authority over Parliament. So Parliament has a number of articles. We're going to go through them as quickly as we can. Well, we're going to go through most of them as quickly as we can, the main ones. So the first, Article 1 of the Human Rights Act, is that commits all signatories to protecting the rights included in the Convention. Article 2 protects the right to life. Article 3 prohibits torture and degrading or inhuman treatment. Article 4 outlaws slavery and involuntary servitude. Article 5 secures liberty and security of individuals against arbitrary arrests and imprisonment, so a right to not be arbitrarily arrested and imprisoned. Article 6 guarantees a free, fair and public trial. Article 7 prevents legislation that criminalises acts retrospectively, which is a very interesting one. So, Article 7, the Parliament cannot pass a law today that bans something and then proceed to punish people who have been doing that thing for 20 years, if that makes sense. You can't pass a law now and then punish people for not conforming with that law if the law wasn't in place beforehand. That's what retrospectively means. Article 8 promotes respect for individuals' private and family life. Article 9 protects freedom of thought, consciousness and religion. Article 10 protects the freedom of expression. Article 11 gives you the right to assembly, so to group and assemble together and protest, and rights to trade unions, for example. Article 12 is the freedom of men and women to marry and start a family. And then we have more articles that we can carry on going through. But these are the first 12 outlines most of the human rights that are protected under the Human Rights Act. So, now we have this act passed in 1998. What were the early cases that included human rights aspects? Well, for one, we have the killers of James Bulger, the case that was in the early 2000s, and the late 90s, early 2000s. So the court imposed a lifetime ban on revealing the new identities of Thompson and Venables, the two boys who were convicted of killing James Bulger in 1993. Okay, this is because revealing their identity would threaten their right to life, which is Article 2 of the Human Rights Act. Okay, so this is a very, very, very famous case in the UK of the two boys that kidnapped and murdered James Bulger, I think a 2-year-old at the time. Okay, and once they had served their time in prison, they got new identities, and it was against the law to reveal this new identities to the public because their right to life would be threatened if so. There's also the case of the treatment of mental patients. So a paranoid schizophrenic killer detained at Broadmoor argued that the Mental Health Act reversed the burden of proof by requiring him to prove that he was cured before he could be released. Okay, so the burden of proof was he had to prove he was not a paranoid schizophrenic, rather than the prosecutors were trying to, the burden of proof being on them to prove that he was. And the Court of Appeal ruled that this act violated Article 5 and Article 6 of the Human Rights Act. So now we move on at the Freedom of Information Act, which is another form of civil liberty. So New Labour's manifesto at the 1997 general election included an explicit commitment to introduce freedom of information legislation. The Freedom of Information Act received royal assent on the 30th of November 2000, but it did not come into force until the 1st of January 2005. It gave citizens right to access information held by public authorities, and it required public bodies seeking to deny requires for information to show that the public interest warrants an exception under the Act. So what has been the impact of this Freedom of Information Act? Most early requests for freedom of information under the Act came not from individual citizens, but more from media organisations that saw the Act either as a means of trying to tie up loose ends on earlier stories. In no area was the use of the Freedom of Information Act more apparent, than in the case of the scandal over MPs' expenses. So, the Freedom of Information Act was enacted in 2000. Well, it received royal assent in 2000. However, it didn't come into effect until 2005. And this was because the government thought that the Freedom of Information Act would lead to a flood of freedom of information requests. And so they spent 5 years preparing for a huge increase in freedom of information requests. However, this was not to be the case. There were very little requests for information, and now this is just seen as a method of uncovering scandals, and also as just to tie up loose ends on earlier cases.